Every year, thousands of people decide to start a business together. At the beginning, everything looks wonderful. Everyone trusts each other, there's a lot of excitement, there is hope that the business will succeed, and because of this excitement, very often people forget about the legal formalities that is a must when you are entering into a business relationship. They fail to discuss difficult questions, they fail to discuss what will happen if the business does not work. They fail to understand who will take the responsibilities, and if for some reason the business fails, then how do they manage to exit from that particular contract? So what begins as a big hope and a big expectation many a times fizzles into a dispute and leaving the parties bitter. So now let me explain to you why we say that a contract is important. In a contract, you will know who owns what, you will know who contributed what, you will know who can make the decisions and who is entitled to the profits. Can one partner survive if the other dies? Can one partner exit if he is not happy with the contract? What happens if the business fails? Then can they wind up the business, and can there be other options available to them when they're winding up the business? Now, all these questions can only be answered if you have entered into a formal contract. Viewers, before it's too late and before you go rushing into a business venture, may I suggest that choose the right business, choose the right business structure, and protect yourself from problems in the future. Visit a lawyer, understand what you should be doing, explain to the lawyer what your plans are, and then move forward. Now, the biggest problem that I have noticed in my long career is that it's very easy for people to say, let's start a partnership. It's so easy. It sounds very easy, but is it that easy? The answer is no. It might seem simple when you are at the thought process or you are at the formative stage. But what happens when the partnership actually works? What happens if the business succeeds? And even more importantly, what happens if the business fails? The answer is very simple. You have to choose the right business structure. You have to decide whether you want a partnership firm, a limited liability firm, a company, a one-person company, or simply a sole proprietorship. Now let us understand what these structures mean. What is a partnership? A partnership is governed by the Indian Partenrship Act 1932, where two or more people agree to carry on business and share the profits as well as the losses equally or in the proportion they decide. This is probably the oldest form of business that has been in existence in the world. There are, of course, many advantages and many disadvantages. The advantage being that it's very easy to start a business in a partnership. Compliances are pretty low. Decision making is usually flexible. Costs are comparatively lower. However, the simplicity comes at the time when risk is allotted. In a partnership firm, the partners are liable for all the liabilities that arise while they're doing the business. The danger of unlimited liability is such, let me give it by example. Suppose you take a loan of 50 lakhs and the partnership fails. Then the 50 lakhs has to be repaid by the partnership firm. But in the event that the partnership firm cannot pay the entire 50 lakhs, the liability will lie squarely on the shoulder of the other partners, which means that the personal savings of the partners is at stake, their properties is at stake, their personal investments are at stake, and overall, you will always have the risk and the uncertainty till all the dues are cleared. So, I would suggest that instead of having the traditional partnership, you should look at other means of business which may also help you when you are starting a business. For instance, a limited liability partnership. This is a concept that has come to India where the parties decide that they will enter into a partnership but with limited liability. It's a structure that takes the benefit of what is there in a company and also the benefits of what is there in a partnership. The biggest advantage, I would say, is the limited liability factor. Again, coming back to the same example of a 50 lakh loan. Suppose an LLP takes a loan of rupees 50 lakhs and they cannot pay back the 50 lakhs, then the person who has to recover the 50 lakhs can only do it from the limited liability partnership and not from the individual partners, because they have limited their liability to a certain amount. Hence, you are much safer in an LLP as compared to a regular partnership. LLP today is considered one of the most favored business structures for professionals, consultants, startups, etc. Now let's come to another business entity, which is company. A company is a legal entity that can be incorporated under the Companies Act. However, unlike partnership, a company exists through its shareholders. But in a partnership, the partners are personally liable, whereas in a company, the shareholders are not personally liable and the company exists as a legal entity. So this structure has its own advantages. They would be limited liability, greater credibility, earlier and easier access to investment, perpetual succession, that is, the company will go on even if the shareholders die, and a very structured governance. However, this particular type of business entity comes with several obligations. These are board meetings, compliances with the corporate governance, such as the registrar of companies, the statutory filings, the auditing, the regular compliances under the Companies Act. Hence, although it is a preferred way of doing business, you can only do it if you're ready to take up all these responsibilities that a company casts upon you. However, if you're looking at scaling up your business in a big way, this would be the best way of doing business because you can get funding. Another structure that has started in the last few years is what is called a one-person company. This particular structure is something in which one individual starts a one-person company. It allows a single entrepreneur to operate as in a corporate structure and enjoy limited liability. It can be very useful if there is only a solo founder and he wishes to separate personal assets from business risks. Now, one question that I have often been asked, ma'am, can you tell us which is the best business structure? To this I answer very simply, there is no best business structure. Much would depend on your ideas, on how you want to grow, on what exactly is your plan 10 years down the line. Based on that, you should choose an entity which will best suit your requirements. Hence, I would say the correct structure would depend on the nature of the business, the number of stakeholders, the risk involved, future expansion plans, and funding requirements. Like I said earlier, if you want to get funding, company is a preferred way of doing business. Also, you have to look at the tax consideration, the compliance preferences. So a small business would better run best as a proprietorship, whereas a professional practice would be better as an LLP. And if you are a startup and you're looking at scaling your business, then company would be a good idea. Now coming to another very important aspect, never enter into a partnership without a written deed. I say this because a partnership cannot be based on trust only. You have to have the documentation. Otherwise, relationships can break because expectations increase over a period of time. If responsibilities and liabilities are not recorded correctly, there is bound to be misunderstanding. Therefore, is an instrument that every partnership must have, that is a partnership deed. Now, what should a deed contain? Again, an important question. It would contain who are the partners, what is the capital contribution of each partner, what percentage of profits are involved for each partner, what are the duties of each partner, who will manage the day-to-day affairs of the firm, who can sign contracts for the firm, who can borrow money for the firm, who will hire and control the employees, who can operate the bank account. Now, these are all extremely important aspects of a business and must be documented to avoid disputes in the future. Certain clauses are extremely important. For instance, capital contribution. Many times partnerships fail because capital contribution is not clearly mentioned. For instance, who will contribute the money, who will contribute the expertise, who will contribute the infrastructure. These are things which must be kept in mind when you are making a partnership deal. The next important thing is the decision-making power. Who will make the decisions in a partnership? Which can one partner make a decision independently without consulting the others? Do major expenditures require the approval of all partners? Can one partner bind the firm in a contract without consulting the other partners, etc.? Another equally important aspect is how to exit, that is, the exit mechanism. Most people discuss how to start a partnership, they never discuss how to leave it. That's a very big mistake. I think you should know how a partner can exit. Is it by retirement? Is it by admission of a new partner? Is it by expulsion? Or is it by death? Sometimes incapacity of a partner can also be a ground for a dissolution of partnership or a firm. If these situations are addressed, you save yourself the headache of long years of litigation. Can a partner immediately start a competing venture? The answer is he can if there is no clause in your partnership deed that prevents him. But he can't if there is a deed that says you cannot start a competitive business for the next 2 years or 3 years. If you have a non-compete clause, you can ensure that your partner does not walk away with your customers, does not walk away with your customers' information, does not take away your business data or the confidential information that you have. Hence, I say that the confidentiality and an anti-compete clause is a must. Again, another very important aspect is accounts. Every business should maintain proper accounts because proper books of accounts help you in the long run. You have written record of how you did business, how you took a loan, how you repaid it, how you paid your taxes, etc. And eventually, this is what helps you to decide how you made a profit, or rather, how you can arrive at a profit. One last thing that I want to tell people is do not mix business and personal finances. Many a times, we notice that people make the mistake of just going and pulling out any amount of money from the kitty without thinking twice that if it's a business expense, they can do it, but if it's a personal expense, they cannot do it. Hence, I would always advise that if it's a personal account, you should keep it separate from business, and if it's a business account, keep it separate from your personal. The last and probably the most important clause is the dispute resolution clause, which I would say is very essential. What happens if a dispute arises? Will you go to a court? Will you go for arbitration? Will you go for mediation? Or would you rather prefer that somebody sits and tries to help you to reconcile your differences? Hence, dear viewers, when you are entering into a partnership, remember there are certain red flags that you must keep in mind. Before entering a partnership, be cautious about a few facts. If the other party refuses to enter into a documentation, if the other party refuses to be transparent, if the capital contribution is unclear, if the profit sharing is vague, if responsibilities are not defined, and if banking arrangements are uncertain, and also if there is no exit mechanism. If you have a well-documented partnership deed or a well-documented contract for any form of business, you will save yourself a lot of heartache, and most importantly, you will save yourself the headache of going to court and fighting a legal battle for years at an end. A very simple rule for every viewer: never enter a business only because you trust somebody. A properly drafted deed does not indicate distrust. It merely means that you're documenting what you want to do in your business in the near future. Bad documentation can destroy your relationship. So with this, I would like to conclude, dear viewers, whether you choose a partnership firm, an LLP, a private limited company, a one-person company, or a proprietorship, remember that structuring your business is extremely important, and you must choose the type of structure you feel will be best suited for your business. If you decide to enter into a business where there are more than one person, you must have a well-documented contract so that you are safe. Disputes rarely arise when you are struggling. Remember, disputes arise when you have made the business successful. With this, I'll end today's podcast. If you want any advice on any aspect of the business, you may write to us in the comment box and we will definitely respond to you. If you require any specific advice, you can always take an appointment with us. Thank you and namaste.